Here today, Nathalie Berger, who is the new Director for Competitiveness Coordination at the European Commission's DG Grow Department. You can all come up and take a seat with your name tags. We have Andrey Corrêa, Executive Secretary at the National Council on Combating Piracy and Intellectual Property Crimes at the CNCP in Brazil. We have Brigitte de Costa-Villaluz, Director General for the Intellectual Property Office of the Philippines, IPOPHL. We have Suvashis Choudhary, a think tank member of the Committee Against Smuggling and Counterfeiting Activities Destroying the Economy, CASCADE, of the Federation of Indian Chambers of Commerce and Industry, and the IPR Committee in India, the Federation of Indian Chambers of Commerce and Industry. Then finally, we have Seng Khonshin, who is Director General for Intellectual Property Protection and Intellectual Cooperation Bureau at the Korean Intellectual Property Office, KIPO. Thank you all so much for joining me here today. So as you can see, we have all corners of the world covered here on this panel. I'm going to start, like the last times, with a question to you all in the audience. This one is multiple choice, so again, you can use Slido to answer this question. The question is, what is the biggest barrier to effective cross-border IP enforcement for SMEs in your region? So it's not that one on the screen, but that'll be up in just a second. So you can, again, use the code IP enforcement on Slido to answer this question. It's multiple choice. Your options for the answers are legal fragmentation, costs, lack of awareness, limited enforcement capacity, or lack of coordination. So I'll come back to this later in the panel and see what you thought was the biggest barrier. So Nathalie, let's start with a question for you. As I mentioned, for SMEs in particular, this can be quite tricky. And so I wanted to ask you what the European Commission is doing to help navigate this in the context, of course, of the rising trade disruption that we're seeing all over the world, the global uncertainty. SMEs are facing increasing challenges generally, right? But in particular, in protecting their IP abroad, especially across diverse legal systems. So how is the EU stepping up its support to help them navigate this complexity? What role can IP play in helping SMEs scale up their businesses? And could you spotlight some of the tools that the Commission has? I know there's the SME Fund, there's the IP help desks for helping European SMEs. How are these making a difference?
Thanks a lot. Thank you for these questions. Oh, can you hear me?
Let's see. Hold on a second here. There you go.
Okay, it works now?
Yes.
Great. Thanks a lot for these questions. And I think it's so important to focus on SMEs and IPs for SMEs because in Europe, SMEs are really the backbone of our economy. And we can see that SMEs which own intellectual property have a very much improved probability of developing. I mean, we have a whole strategy on startups and scales-ups in European Union, in the single market, and we really want to help them to strive, to develop. In order for them to strive and develop, first of all, to have access to financing and to develop on the market, they need to have IP protected rights. For that, we are providing support to have an easier access to the protection of IP rights. So we have set up in place what we call the SME Fund, which is a fund that we implement together with the European Intellectual Property Office, our agency, to give them money to have an easier access to the protection of their rights. That's the first thing. We're also looking into how to help them develop to have an easier access to finance. And there are a number of actions that are being put in place by different instruments. We're looking into the possibility of activating guarantees. We have a huge fund in the European Union that is called EU Invest, with a very, very strong potential. to give them guarantees. We have direct investments, notably by the European Investment Bank, with provision of equity capital to venture capital in order to facilitate venture capital investments in SMEs to develop the IP rights, etc. That is extremely important. Then there is the international aspect. And IP plays a strong role in our international dialogues and in our international agreements, in our free trade agreements, etc. We have IP enforcement dialogues, and we use these IP enforcement dialogues and the trade negotiations with our global partners in order to advocate for a stronger and a more harmonized enforcement system across the borders, so that the investments of SMEs receive really adequate protection globally. And then there is the third aspect, or the third angle, which is to support the third countries, or some selected third countries, through EU-funded programs on technical assistance and international cooperation to strengthen the protection and the enforcement of IP rights. And we have developed these programs in a large number of regions on the globe, so I can mention Southeast Asia, Latin America, China, Africa, the Caribbean, South Korea, Japan, Moldova, and Ukraine, so very, very largely. And there we really try to contribute to avoiding market access barriers to our SMEs. So we're also thinking of the international development of our SMEs. And we want to act to prevent unfair competition from counterfeiters and infringers who would otherwise undermine the interest of our SMEs. I can also mention tools like the EU Counterfeit and Piracy watch list. The latest one was published on the 22nd of May, in which we do identify a number of marketplaces where IP enforcement remains problematic. And then we try to square the circle between the identification of the marketplaces, the problematic actors, and our more general commercial relationship. You already mentioned the help desks. So we have the support that is provided internally, and there again our agency, the EU IPO, plays a crucial role. And all the activity on the help desk internationally. So you see, this is really an integrated strategy. We want to support, facilitate, first of all, access to SMEs to IP rights, because having IP rights will help them having a better access to the market, will help them better developing internally in the European single market and with a view to external development. And we're working on the international context and international enforcement as well.
Great, thanks, Nathalie. So let's move from Europe to South America. Andrey, you're coming from the CNCP in Brazil. So we know, of course, that online counterfeiting knows no borders. Brazil has its national plan for combating piracy, which places a strong emphasis on online counterfeiting. How are you guys working across borders and across jurisdictions to block and prosecute offenders, particularly given the surge in cross-border e-commerce?
Well, thank you for the question, Dave. Good morning, ladies and gentlemen. Good morning, my colleagues. It's an honor to be here talking a little bit what are we doing in Brazil against IP crimes. And first of all, first thing I have to say, at the border have two sides. And there is a strong connection with what happens in the borders and what happens in the e-commerce market. And CNCP is a forum. It's a committee that gathers together more than 200 entities from public and private sector. and it's formed in 2005. So since then, Brazil believes that only with integration between private and public sector we can move effectively against those crimes. We know that society have a not very good vision about IP crimes. So this coordination between public and private sector is essential. And well, especially in the last 3 years, we changed the approach of CNCP to become more an intelligence organization rather than just a forum to discuss IP-related crimes. And that was only possible because we received and treat a lot of data and knowledge coming from the industry and transform those information in intelligence. And we strongly believe that a good public policy, it's only possible if it's subsidized by intelligence. And from my personal perspective, the question is responsibility and trust. Responsibility from e-commerce platforms and social networks has become a huge market, and trust in what the industry have to give us, especially data. So the last bigger operations that CNCP has done was only possible because industry bring us the problem, the right way to approach the problem, and enough data to advance. And well, to work with industry is sometimes complicated because, of course, we know that we have different interests, but we have found a lot of convergence between public and private sector in Brazil. Also, about the borders itself, we have been working with WIPO in the context of Mercosul to incentivize the creation of other organisms, other committees or councils that bring together private and public sector. Again, we strongly believe in those in this strategy. And this CNCP itself has two ways to act, I mean, against IP crimes in the e-commerce market. First of all, we have administrative notifications directly to the e-commerce platforms demanding the removal of the content. And we began with individual URLs. Then we moved to entire groups on social networks, and now we are demanding the removal of the entire store in the e-commerce platform. And we are just bringing the IP-related legislation to other legislation, like the legislation to protect consumers and protect the public health. We know that, for example, counterfeiting medicines is a growing problem in Brazil, also here in Europe. And about this, it's interesting and sad because we realize that when we took those actions against e-commerce platforms and social networks, and we show to the press the name of the companies, we have a level of effectiveness, 100% in most of cases. And when we omit, when we don't tell the press what are the platforms, they don't do much, they do less. So we see that image, public image is important for those companies, and it's sad that we have to show the names to the press to make our policy more effective. And this is a thing that we think must change. The platforms must take actions, proactive actions. And it's important to mention also that this week the Supreme Court of Brazil just decided that we will gonna bring more responsibility to the platforms. So nowadays in Brazil, the platforms just wait a notification or a judicial order, and will not be like this anymore. The Supreme Court is demanding proactive actions, and we believe this is very, very important. And just to mention, I mean, we had some cases that I could pick up here. But one case in particularly is very interesting because involved not only a seller, not only a social network, but an influencer. An influencer that create a store, a page on Instagram with the name Dental Without Warranty or Odontology Without Warranty. This guy had 52,000 follows, and the majority dentistries and medicine and other professionals of health. And in this case, we not only bring down the page on Instagram and the store on an e-commerce platform, but we also gather the intelligence to the prosecutors to go to investigate this guy, and now he's facing a process that can bring not only IPR crimes, but also crimes against public health with a penalty of 20 years in jail. So we strongly believe bring together more crimes to enforce the IP-related issues. And yeah, I think that's it for my first question. That's
a very interesting legal development there. So let's now move from Brazil to the Philippines, to Brigitte Costa-Villaluz. So IPOPHL has just adopted a centralized data system and the FIPS strategy. Can you tell us a little bit about that and how that is improving not just information sharing, but also legal alignment and cooperation with other countries in Asia and further afield? And what do you think other countries can learn from the Philippines' data-driven approach in fighting IP crimes?
Thank you, Dave, and good morning, colleagues and new friends. We are grateful to EU IPO for the invitation for us to share our experience in the Philippines in the cross-border challenges in the IP enforcement, including SMEs. So with respect to what you mentioned on the strategies of the Philippines, around the time that we had the PIPS was really the time when there was a pandemic, and with a country of population of 115 million, you can just imagine the amount of internet transactions that were occurring. You know, the Philippines is a country where there is trust between what you call a suki, or a buyer, a loyal customer, and a seller, and without face-to-face or physical transactions. The suki, the loyal customer, would go by brands. And if you go by brands and trademarks in the digital space, and it is flooded with cheap, plenty, fast arriving goods from different countries in parcels with little control, you can just imagine how much counterfeiting and piracy occurred. So around March 2021, the Intellectual Property Office of the Philippines embarked on a e-commerce memorandum of understanding with that first 12 signatories. Unlike the other approaches where there was a strong hand, IPOPHL thought of having more of cooperation among the stakeholders. So what the MOU does is to have in place a voluntary system of notice and takedown. So easily we were able to discuss and convince the digital platforms to come on board. So we have 4. We have Lazada, we have Shopee, we have TikTok Shop, we have Zalora. And then we now have 94 rights holders and companies, and this is where it became very important because there was no discrimination on whether you are micro, small, middle enterprise. In fact, as with the EU and other countries, we are a country where the MSMEs, and that includes the micro enterprises, are the backbone of the economy. We are talking of more than 99% supported by our MSMEs. And so with this e-commerce MOU platform in place, we discussed yesterday how it is very expensive and time-consuming to litigate, to enforce. I was a litigator in enforcement before. I assumed my role as Director General of the Intellectual Property of the Philippines, and we know it can take years, even decades, until you find and arrest an infringer. And so the MOU is an equalizer because it does not matter, it does not discriminate among the signatories. So you can be a jewelry maker, a designer of bags, an artist, a musician, and in fact we have that portfolio. We have pharmaceutical companies, cosmetics. We have food, clothing, lifestyle, and with 94 signatories of brand owners, we have 9 chambers of commerce, including the European Chamber of Commerce in the Philippines and American Chamber of Commerce in the Philippines. So right now we have 107 signatories. So we believe this model is effective because the lines of communications are opened. The platforms are very cooperative. The rights holders have their focal persons where there is a direct communication. And IPOPHL facilitates on the onboarding of the signatories, and we also facilitate and assist in the yearly review. So we believe that if we have more companies on board and more cooperation, we will have better results. As was shared earlier by Alibaba, the figures are the same. The proactive takedowns with the reporting system among the stakeholders and digital platforms are from 85% to 93% in the past year. So there is no need to file a case. There is only a need to communicate with each other. And so we hope that we continue, IPOPHL will continue to assist and have more of the stakeholders on board to trust the system so that the Suki, the loyal customer, and the sellers will again be in a system where there is trust even in the digital space.
Thanks. So now let's move from the Philippines to India. So Suvashis, FICCI obviously is dealing with a rapidly growing digital market in India. What would you say are the main challenges for IP enforcement given that rapidly growing market? And how are businesses and governments working together to address this, particularly when trying to make IP enforcement more effective across borders?
Thank you. Good morning to all of you. Digitalization is taking all over the world, but India is witnessing a very, very rapid growth in digitalization, both in scale and speed. I will not overemphasize the benefits of it, but some of the negatives which are there, like someone mentioned, the kiss of death, it is too telling and very, very impactful. Now, unfortunately, the enforcement part is lagging, is not really keeping pace with it. Now, with digitalization, one can say it's an enabler of infringement, of IP infringement. Online piracy, counterfeiting, trademark violations are rampant across geographies and platforms. But what is very problematic, apart from the different jurisdictions and different IPR policies and different takedown policies across platforms, to me, I think the most important is our mindset. We somehow have this xenophobia that my IP and my property is important, is valuable, and I don't care about yours. So this thing has to go. Otherwise, it'll be the last coffin in the nail, last nail in the coffin of creativity and innovation. Slowly, it'll die down because with AI and with the kind of things that are happening, I think that is very, very important that we change our mindset somehow. And we are victimized together. We are all victims. We are all sailing in the same leaking boat. So we have to mend the boat as soon as possible. There might be differences. We have to take care of that. We have to, move around that, and we have to really take a very, very holistic view of the whole thing, rather than be very narrow-minded about all these things. We have to build a IP ecosystem, especially enforcement, which is based on people's policy and technology. We have to all, these things should come together. We can't just work in silos, just to talk about awareness and all that. So our effort in India and FICCI, the organization that I'm representing today, is taking a lead role in this process. So we have taken a lot of initiatives in India, and I'll just recount the most important ones. Now, these are some of the things which are enshrined in our IPR policy of 2016, and some of the other acts, not necessarily IP acts, but acts like cinematography, the Information Technology Act, the Consumers Protection Act, etc. Now, the first thing which I would like to, the effort which has been done is about IP awareness mission. Now, spreading IP awareness, it is to tell people, to tell businesses, to tell entrepreneurs that these are your property, these are your IPs, and these, you should recognize this, you should use this for your business strategy. And at the same time, when you know that it has to be enforced, you have to enforce, you have to respect others, that is foreigners or any other IP owners' rights as well. So this is the first step, which is, I think, very, and we are taking a whole lot of entire, we are targeting school children, college students, law students, and the whole lot. Second one is the capacity building of law enforcement. So, compared to India is a very, very big country. I was astounded by my Filipino. We are 1.5 billion. Now we have to, and somehow for law enforcement, for police, IP is still a sort of a very privileged VIP kind of a tag which is attached to it. There are other more pressing problems which they have to handle. So they have to go up the priority. So we have to somehow build their capacity for this. Now, the internal processes have also to be improved, and government is doing a lot for this. We have the e-filing portal, and you'll be surprised to know that about 100,000 patents were registered last year. There were less filings, which means the backlogs are being cleared. So this is our effort, but still we are about 1/10 of capacity of patent handlers, patent examiners compared to China. So we have still a long way to go. What is one step which we have taken is very important, it is paying a lot of dividends, is creation of special courts. And in the high courts, which are the main court of all the states, we are creating the IPR divisions. Now they are really giving a good result, not just in terms of the number of cases which they are handling, but the quality of the judgments or the orders which they are passing. Now they are very good. We have to do a lot of, this has been coming up again and again about collaboration, public-private partnership. So we have to really collaborate with the law enforcement, and we are doing it with the customs also. For example, real-time customs recordation to stop cross-border movement of counterfeit goods we have undertaken. And we are also giving support to businesses to navigate through all these, it's not a very easy to understand, but the IP field is very complicated. This is one, and then we are promoting alternate dispute resolution within the country. And then the most important is we are having a lot of bilaterals and multilateral agreements, including, the FICCI had with WIPO recently. Now, all these are having a very salutary effect, a positive impact on our system, both in quantitative and qualitative terms. But the most important is a growing realization that we cannot act alone. We have to be proactive, like they say, and we also have to collaborate with other nations. There's a growing realization that IPR is no longer a peripheral issue. It's a very important issue, and it is central to innovation, investment, and international trust. Now, all these are very important ingredients for the India growth story. We are, evolving, though not at the same, at the desired speed, but the direction is clear and the momentum is real. Thank you.
Thanks very much. So let's move from India to South Korea next. Sang Kon-shin. In 2025, the Korean IP system rose to the top 10 of the International IP Index of the U.S. Chamber of Commerce. How would you say that international cooperation agreements and your strategic partnerships, I'm thinking in particular the EU-Korea IP Action Project, how have those projects strengthened your cross-border IP enforcement? And what key strategies do you think have been most effective in improving that cooperation?
Thank you for the question. Good morning to everybody. As you mentioned, Korea has entered the top 10 of the International IP Index for the first time. The interesting thing is we were ranked 12th for 3 years in a row, and in 2023, 11th, and finally top 10. It looks like a mother student. And this progress has been driven in large part by cross-border international cooperation, but I'll talk more about international cooperation in the next round. And for now, let me highlight key strategies that I believe have worked best in Korea over the past few years. Firstly, we expanded the Special Judicial Police, or SJP's role. Korean Intellectual Property Office is quite unique. We actually have the authority to directly investigate IP crimes, which most IP offices don't. Initially, the authority was limited to trademark cases only, but since 2019, we have expanded it to include the patents, designs, and trade secrets. Our IP police work closely with both domestic and international foreign IP enforcement agencies. Thanks to their technical expertise and these interagency cooperation, they have built a strong reputation for dealing with the complex IP cases. And secondly, hottest topic yesterday in this summit, AI. We've developed the AI-based monitoring system to track down online counterfeits. This system is able to identify suspicious sellers and listings. And sometimes even when brand names are disguised and product images are modified. In 2024 alone, this system has helped to take down more than 200,000 counterfeit listings from global online platforms. And we expect better performance this year as we expand it to cover more brands in 2025. Lastly, we focus heavily on supporting SMEs. Usually many small businesses don't have their own legal teams or international offices. So it's very hard for them to respond when their IP is infringed abroad. That's why we are running 10 IP support centers in 8 countries, where SMEs can get their legal advice and enforcement supports when the IP is violated overseas. To summarize, Koreans' enforcement strategies stand on 4 pillars: strong laws, and well-trained investigators, AI-based monitoring system, and cross-cooperation across borders and agencies. And above all, we do this with the SMEs in mind. Thank you.
Thank you very much. So now I want to go check in with the answers you've given on the Slido poll question, which was, what is the biggest barrier to effective cross-border IP management for SMEs? And we have a very clear answer here, I think, which is costs. So as we mentioned at the outset, if you're a big company, you can hire these big firms, law firms and investigators to figure out where IP infractions might be happening. You can have the legal authority legal resources to tackle it. If you're a small SME, not so much. But I see also limited enforcement capacity came second, which is, I think, also this same question of resources for SMEs, that they're just working with less resources than large companies. So Nathalie, with that in mind, let me ask you some more about these tools that are available to SMEs. We're running a bit short on time, so if I can ask the panelists to keep their answers brief in this round. So we know that the EU is not only providing financial and advisory tools for SMEs, which you talked about before, but also there's strategic direction through policy. For instance, there's the EU recommendation on measures to combat counterfeiting, which was adopted last year, and that includes strong elements on IP enforcement. So how do you see that recommendation adopted last year contributing to more effective cross-border enforcement, and could it serve as a model or inspiration beyond the EU?
Thanks a lot, Dave. I think we should just have a quick look at numbers. In the EU, the IP-intensive industries account for around 47% of the EU GDP. And that is worth over 6.4 trillion euros. And I'm not even mentioning what it represents in terms of employment in the European Union. That's one thing. Now, other figures which are very important is to look at the number of counterfeited items that we seize, which only gives an indication of the state of the situation. In 2023, 152 million counterfeit items were seized in the European Union. Not only, consumer goods such as false handbags, but also dangerous goods like fake medicines, pesticides, or essential spare parts for trains and cars. So really something that can have an impact on the safety, the security, and the health of our population. So that's just to look at the scale of what we're talking about. We have adopted in 2024 this recommendation as a response to the growing, and I would call it the systemic threat that comes from counterfeit goods entering the European market. In this recommendation, we have measures to combat counterfeiting and to enhance the enforcement of IPs. So to establish in the European Union a coordinated and a comprehensive approach to IP enforcement that really tries to address the realities of today's landscape, which is digitalized and which is a global landscape. So with the recommendation, we promote cross-border data sharing, we promote public-private cooperation, we promote the use of new technologies, including AI, for smarter IP enforcement. And we also outline concrete actions and best practices for intermediaries, which are transport, payment, and social media providers, to prevent the misuse of their services by counterfeiters. And we also provide tools for SMEs, a cyber theft prevention toolkit to help them to better prevent and to better act against the cyber attacks which are targeted at their trade secrets. This is something that we have observed is increasing and very cross-border in nature. So these are very practical steps, and we are actively promoting this. So there is a concrete enforcement. Our agency, the EU IPO, plays a key role and cooperates with other agencies such as OLAF for the protection of the financial interests of the European Union, Europol, which works with the national police, the European Prosecutor's Office, and CEPOL, the European agency that provides training for law enforcement officials. So the law enforcement officials are familiarized and trained in order to focus their efforts on IP enforcement. And now to look into the international dimensions, we have this memorandum of understanding in the EU. When we have the memorandum of understanding on the sale of counterfeit goods, we have observed that it has served as a source of inspiration for other countries, like, for example, in the Philippines, and Brigitte just mentioned it, and we really believe that this type of instruments, which are soft law instruments, but very powerful instruments, they can really help to foster cooperation between online platforms and right holders, and we really believe that they can be adapted to the different legal and markets environments. And we really promote these models actively through our international dialogues and the cooperation framework, like, for example, the IP Key Southeast Asia. And we are absolutely ready and more than willing to continue exchanging best practices and to exploring how, with this approach, we can even further strengthen our international cooperation. And of course, the context of our free trade agreements or our cooperation agreements on a global basis is the very appropriate one to promote this cooperation.
Yeah, you mentioned the free trade agreements, and of course, right now between the EU and Brazil, we have the Mercosur agreement working its way through approval. And so it's estimated that that will increase trade between Brazil and the EU by 5.1%, which is a big economic opportunity, but it could also create new opportunities for IP infringers, right? So, Andrey, how is Brazil preparing to support SMEs in this evolving landscape? And do you see regional partnerships or enforcement networks playing a bigger role as we see this increase in economic activity in trade? And would you say there's a scope for a more formalized legal alignment or mutual recognition in international IP enforcement with Mercosur?
Thanks, Dave. President Lula made it very clear to his team that the agreement between EU and Mercosur is a priority, and we must be ready. Brazil knows the important role that we have in the region. We are the stronger economy in the region. So that's why right now we are working in several projects that aims to bring together the countries of Mercosur. Especially we are having a lot of support from WIPO to talk with other Mercosur countries to establish better relations. We know that we have a lot of different perspectives in Mercosur, but we have been successful to talk with Argentina, Paraguay, and Uruguay about IP crimes. And of course, we have signed also, since the beginning of this administration, memorandums of understandings and agreements with other countries like Denmark and France to expand this network, especially in campaigns to the public and other perspectives of fight IPR crimes. And like I said before, we have this challenge to work together with all stakeholders in Mercosur. We have this diagnosis that not all the countries of Mercosur had forums or space where industry and public sector can exchange information, and we strongly believe this is important. So, furthermore, I think what we strongly believe and strongly incentivize the creation of other councils or committees against IP crimes in both markets with executive powers to enforce the law, at least at administrative level. We think this is very, very important, and to assist, when necessary, the work of judges and prosecutors. And another challenge, from my perspective, regarding the agreement, I think we should create a methodology to treat the data and the information that come from industry. All countries of European Union and Mercosur have, well, we deal with this data in different ways, and I think we can discuss together the two markets, how to deal with this information, and how to advance more. So that's it.
Thanks. And I also wanted to ask you, we had a question come in from the audience on Slido. You've piqued interest with the Supreme Court case. What's the name of the Supreme Court case, the person asked? So they can look it up.
This case is about the Article 19 of a law that deals about liberty, expression liberty on internet. This law said that only with a judicial order, the platforms should remove content. From our perspective, we don't follow that. We follow the consumer's law that said that all products, piracy or counterfeiting, are illegal and unfit vote for the consumers. So we had this clash between legislations, and now the Supreme Court is saying very clear that the Article 19 is not constitutional. So the platforms have responsibilities, and now, I mean, we already have the majority in court. Now we have to see how they will modulate the effects. But I already know that piracy and IP crimes will be touched in the decision of the judge of the Supreme Court.
Okay, so on Article 19. Brigitte, you talked a bit about FIPS and how it's having these measures for SMEs. What specific capacity building measures does FIPS have that have proven most effective? And do you think those could be adapted by other ASEAN countries or developing countries that are facing similar IP challenges?
Yes, Dave, yeah, thank you. So we have capacity building for the MSMEs that are signatories to the MOU. But not only that, the Philippines is very active in its support of innovation and technological support offices, which are the TISC under the WIPO, Technology and Innovation Support Centers. So right now we also have 103 in the Philippines, and these are the state colleges, universities, higher learning institutions. And early this year, the Philippines was named chair by the ASEAN for the TISC network. And the TISC network is very important because we are able to assist young students, the colleges and universities, to guide them in all their IP filings. So it is all about first protection. You identify the IP assets at school age of what you can protect, and your educators are able to assist you so that after the filings and getting the registration and protection, it does not stop there with the registration. You are also able to be assisted as a startup. and it is launched as a startup as much as we can. So I think that this is something the Philippines will share. Later on this year, we will have a TISC activity for the ASEAN with the other delegates, and it is a model that has proven very beneficial to driving the economy. Again, we start from micro and small enterprises, and we start with children at the age where they still dream and are able to see possibilities, opportunities in the world without, being tainted with all the problems that we here who are in a capacity to guide them and help build them can. So
Good,
that's the contribution we feel that we can give.
Suvashis, next question for you. So earlier this year, FICCI and WIPO, you were referring to it before, they signed this memorandum of understanding to boost the IP ecosystem for Indian SMEs. Can you tell us what steps FICCI is taking on the ground to support SMEs to make sure that actually translates to benefits for them?
Oh, okay. On the ground,
Oh, sorry,
of course.
that's a question for Suvashis.
Thank you. When we are talking about SMEs in India, it's a very vast range from technology-driven modern startups to very old traditional handicrafts and cottage industries. All of them have problems, which were mentioned earlier. Resource is one, not just money, it's time also. They don't have the time to pursue this. They don't understand IP, the complexities of IP and IP enforcement. FICCI, this organization, the Federation of Indian Chambers of Commerce and Industry, has been working with SMEs for a very long time, and it is eminently suitable to deliver whatever the WIPO programs and the other programs which come out of its collaboration with various organizations. But there are three particular, although these are, these are early days, but there are three areas in which this collaboration, this MOU with WIPO will help. First is awareness and capacity building. Now, FICCI has been working, via the IP Facilitation Center of the Government of India. But now with this, a new IP for Business Center would roll out. Now they'll be able to, with this, they'll be able to leverage WIPO's IP diagnostic tools, which are available in some of the Indian languages also, very, very critical for us. Then sector-specific IP playbooks can be developed and will be developed. When we talk about SMEs in India, we have violations of all sorts. For example, we have textiles, apparel and fashion. Now they are basically concerned with the nature of IP infringement is design and copying and brand misuse on global platforms. Handicrafts, similar, about GI tags are misused. Then it can be consumer goods like FMCG, is counterfeits, copycat branding. You have IT and software. You have software cloning and software piracy. Then you have auto components. So the entire range is there in SMEs, and all of them. There's no one solution which fits all. So it has to be really, customized for the sector. The second area is cross-border enforcement, and in this, so far, the focus of FICCI has been domestic infringement, but now it can be taken out, and the SMEs can be provided in a very structured, institutional way access to international enforcement tools, including takedown procedures. So this is one area. Then intellectual property can be incorporated in the contracts, which are WIPO ADR clauses, so that these can be enforced without resorting to court cases abroad. then some of these arbitration and mediation resources can be used. So in cross-border enforcement also, there's a win-win situation. And the most important is policy advocacy. Now, FICCI already has a very trusted presence in domestic as well as international forum, like, Government of India and its various agencies, WIPO, Interpol, the Customs Union and trade forums, etc. Now, that can be leveraged to advocate for some kind of a mutual recognition of IP court orders of the foreign country without really going through the rigmarole of filing for another year. If, like I mentioned, if the courts are mature and sometimes they in favor of, they give a ruling against the government also, not in IP cases, but in other cases where a foreign entity is involved. So, it's a very fair kind of a system there, and all the due process of law is followed. So if that be the case, if our court can be like this, your court is also like that. So why not have some kind of a mutual respect for each other's court's order? So this is one thing we would like to advocate, not just through the YPO, but in other multilateral institutions also. And then some of the SME-friendly norms for IPR enforcement can be adopted, and also that we can collaborate with foreign IP offices for the best practices and knowledge sharing and all these. So there is there's a lot to gain, and this is just the initial days of WIPO collaboration. We want to have such collaborations with others as well.
And finally, Sankon Shin, you mentioned before the EU Corrêa IP Action Project. Can you tell us a little bit more about how these types of international collaborations are allowing you to strengthen cross-border enforcement?
Thanks for the question. As I mentioned earlier, cracking down on online counterfeit across borders is one of our top priorities, and we cannot do this without strong international cooperation. So let me share some recent examples from our experience. First of all, we have strengthened our partnership with the European Union. Last year, we signed the new Korea-EU IP Action Project, which expanded our cooperation beyond just the legal frameworks like examination and trial into enforcement activities. And we've had a strong relationship with the European Chamber of Commerce in Korea, or ECCK. Whenever we carry out enforcement operations against the counterfeit of European brands, we directly coordinate with these ECCK member companies. So recently, ECCK told us that thanks to these joint efforts, counterfeit visibility in Korea on and offline has gone down significantly. And we are working closely with the large online platforms like Alibaba, Lazada, and Shopee, which are very influential in East Asia. With them, we share data on repeat infringers and ensure takedowns. Over the past 3 years, this collaboration has helped us block more than 600,000 online counterfeits. And we are building close ties with other IP offices in the region. Through high-level meetings, we exchange the best practices on stopping online counterfeit and tackling bad faith trademark filings, which remain a serious challenge for cross-border enforcement. And let me share our enforcement cooperation with the foreign agencies. In 2023, we found a new form of design infringement scheme and shared the data with the Interpol. And in response, Interpol issued the first ever popular notice in IP history at the time, disseminating it to all 196 members. And just last month, we worked with the U.S. Homeland Security Office in Korea, U.S. Homeland Security Investigation Korea. They contacted us after tracking a suspect involved in shipping counterfeit to the U.S. we found that the suspect was selling large volumes of fake clothing brand through YouTube and Instagram live streaming. So we responded quickly and took joint enforcement action with them. Like this, as the global online trade continues to grow, these partnerships will become even more critical, I believe. Thank you.
Thanks very much. And thanks to all of the panelists. I think it's been really critical to be able to get this global perspective from all of you, because we can see that different parts of the world are dealing with the same IP enforcement challenges, but also with specific challenges. But I can see from the various different partnerships that we've been talking about here between all of you that we seem to be making strides in terms of this international cooperation. So thank you to all of you so much, especially those of you who traveled so far to be here. How about a round of applause for our panelists? So now we're going